Hello students, this is exercise number 26 of the Progressive Monthly Magazine March 2022 on the speed of 100 words per minute. Start. The appellant plaintiff filed the suit for specific performance based on the agreement. In the said suit, he has also prayed for an alternate plea that the respondent may be directed to refund the advance amount of 4 lakhs along with interest at the rate of 18% per annum. The appellant also prayed for permanent injunction. Upon consideration of the evidence adduced by the parties, the trial court directed the respondent defendant to repay the sum of rupees 4 lakhs to the appellant with interest at the rate of 12% per annum for the sum of rupees 2 lakhs from 23/9/1998, for another sum of rupees 2 lakhs from 14/7/1999 till the date of realization. The decree of the trial court was challenged by both the appellant plaintiff as well as the respondent defendant. By the appeal preferred by the appellant plaintiff on the ground that the appellant has not provided the sale agreement. The appeal preferred by the respondent defendant was allowed on the ground that rupees 2 lakhs were received on 23/9/1998 and another on 14/7/1999, whereas the plaint was presented in the court was only on 14/9/2004. The suit has been filed beyond 3 years after the receipt of advance amount. On those findings, the High Court held that even the refund of the advance amount is barred by limitation and the appellant is not entitled to refund also. The appellant has preferred the special leave petitions before this court and the same came to be dismissed on 8/5/2013. Thereafter, the appellant has filed review petitions before the High Court and the review petitions also came to be dismissed. Being aggrieved, the appellant has preferred these appeals challenging the dismissal of the impugned judgment and the review petition. In OS number 4700/2004 before the City Civil Court, Chennai, the appellant has deposited an amount of rupees 4.50 lakhs in BR number 302 and the same is lying in the court deposit. According to the respondent, as on date of taking possession of the property, that is 12/10/2018, the arrears of rent payable by the appellant is rupees 33 lakhs. For the recovery of the said among the defendant has filed on 10th November 2016. On raising of pecuniary jurisdiction of the City Civil Court, Chennai, the said suit filed before the original side of the High Court of Madras has been transferred to the City Civil Court, Chennai, and renumbered as OS number 4748 of 2019, now pending on the file of 6th Additional Judge, City Civil Court, Chennai. During the course of hearing, certain suggestions were made by the parties for amicable settlement of the matter. Respondent and the subsequent purchasers have filed affidavits stating that the arrears of rent from the appellant as on 12/10/2018, that is the date of taking possession of property, is worked out to rupees 33 lakhs. In their affidavits, they have stated that they would be satisfied if the amount of rupees 4.50 lakhs deposited by the appellant to the credit of OS number 4700 is paid to them, and they are ready to withdraw OS number 4748 oblique 2019 filed by them for recovery of arrears of rent. They have also stated that they would receive rupees 4.50 lakhs along with accrued interest in full of their claims in respect of the property and other claims from the appellant of the suit property. The appellant has also filed an affidavit stating that the respondent may be permitted to withdraw rupees 4.50 lakh deposited by him before the City Civil Court, Chennai, in OS number 4700 oblique 2004, provided that if there is no further claim by the respondent and the subsequent two purchasers, in view of the terms of settlement arrived at between the parties and taking into consideration the affidavits filed by the parties, the impugned judgment of the High Court is modified and the appeals are disposed of with the following directions. The respondent are permitted to withdraw rupees 4.50 lakh along with accrued interest, if any, which has been deposited to the credit of OS number 4700 oblique 2004 before the City Civil Court, Chennai. The amount of rupees 4.50 lakhs along with the accrued interest, if any, shall be equally apportioned amongst the above four persons. The receipt of rupees 4.50 lakhs along with accrued interest, if any, would be in full of all the claims by the respondent and the subsequent purchasers against the appellant for the property in OS number 4700 oblique 2004. The respondent and the subsequent purchasers shall withdraw on the file of the 6th Additional Judge, City Civil Court, Chennai. Since the parties have amicably settled the matter, the 6th Additional Judge, City Civil Court, Chennai, shall pass the consequential order.